No. Yeah, okay.
We're just taking clock watching to a new extreme. No, just preserve my rights.
All right, so we got the Matt's ad there, that's to be listed, because you're right. We also don't want to give the affidavit the authority to do funny things by just not filing the affidavit.
I just noticed that.
Yep, okay, that's right, we talked about that. Okay, what else in the way of what we covered last time? I think, let's see, yeah, that's right. So I think
we didn't get to summary determination.
Nope, I think we ended on section 12, so let's start there.
So would you like me to go back to the last version maybe to see what we changed from?
Yes, that'd be great, Well, I tell you what,
No, you know what, because we haven't worked on it.
That's right, that's what I was just gonna say, let's walk through it. This is section 12 now, we're on page 10. For everybody on the phone, let's make sure we're all on the same page. It's LC 8888 with the date 12/14/18. Section 10, section 12, page 10, summary determination. A creditor of the estate who's been presented with the time permitted and disallowed by the affiant in whole or in part may, within 30 days after the date of mailing or delivery of the notice of disallowance, file with the probate court the petition for summary determination. B, a creditor of the decedent whose claim is listed in the small estate affidavit as disputed may, within 4 months after the filing of the affidavit or amended affidavit listing the disputed claim, file with the probate court a petition for summary determination. Oh, so those are 2 time limits, 30 days or 4 months, depending on if you're listed or not. Section 2, the court shall hear the petition for summary determination without a jury after notice to the creditor and affiant, and any interested person may be heard in the proceeding. I think that's current law. The claim may be proved as provided in 115-195. Upon hearing this section, a hearing under this section, the court shall determine the claim in a summary manner, shall make an order, not a judgment, allowing or disallowing the claim in whole or in part. An order of the court made upon summary determination may not be appealed and may be enforced only by filing a petition for summary review, and that's our crosswalk to summary review for the means of enforcing an order on summary determination. Questions about 12? I think it looks good. Hey, John. All right, section 13. This is our fiduciary duty. The fiduciary is under, the affiant is the fiduciary, is under general duty to administer. We did talk about this last time. Preserve, settle, distribute the estate in accordance with the terms of the will, the law of intestate succession.
Oh, I fixed that.
You did?
Changed it.
Yes, you did. What happened?
It used to have all those chapters listed, and now it
Yes.
says this instead.
Okay.
This is, so it's the terms of the will, intestate succession, and the small estate statutes, basically.
I don't know if "and" works there, because if it's a will, you won't administer it under the laws of intestate succession.
Unless you're partially intestate.
That's true.
Well, I feel like you have to follow all those.
And/or, yeah.
All in favor?
I mean, does LC do something like as applicable or anything like that?
Yeah, sure.
That's sort of your.
Like you don't need that. I think you're supposed to follow all these laws as they apply, but if you really want it as applicable.
Or as they apply to the estate or something like that?
Sure, why not? I'm in a charitable mood.
Okay, it's Christmas. All right, let's do that as.
Never thought there'd be a perfect application for and/or.
Well, you know, as they apply or to the estate or as applicable is sort of just a longer way to say and/or. And 114-505 to 560 as expeditiously and as with as little sacrifice of value as is reasonable under the circumstances.
I just kind of have a general question that just
came
in my mind
Okay.
because of the previous about if it becomes where the affiant no longer has, their authority terminated because of
Right.
the estate value. If they were a bad actor, I understand if they were a bad actor during the time they actually were in authority that they would fall under their fiduciary, and they'd be liable as fiduciary. In that little interim time between the time they no longer their PR asks for those assets, if they do something in that interim time, that is the asset. Like, I still have parameters on the ring, I'm not turning over the PR on it. That is a different liability.
It is, that's liability to the PR.
Yes, I just wanted to.
That'd be converted.
Yeah, that's right.
I just wanted to make sure that was what we were.
Yeah, that's a good point, because they're not the affiant at that point, and we don't want them to be the affiant, because we wanna make sure, clear that they have no authority once that occurs. But you're right, if they do something stupid or nefarious, then they're gonna be liable to the PR, just the way anybody who secrets property or converts property of the estate would be. Yeah. Do you wanna make a note to Susan to make a note to that effect, that, this section doesn't apply to an affiant whose authority has been terminated under section, is it 7? What section was that?
Oh, I'm sorry, which one?
The one that terminates the authority if you,
Oh, it was section.
It was section.
It was section 4, but it was subsection.
oh, yeah, that's it, 4/7. So it doesn't apply, but they are liable to the personal representative.
Can we go back to 7?
Yeah? No. Somebody gotta get, no, what?
4-7 or 7?
Page 3, sub 7?
Page 3, no, page, what?
The sub 7, what we're talking about, section 4.
Oh, okay, all right, gotcha.
If the fair market value of the property listed in the amended.
To be listed, so it's,
To be listed.
yeah, it hasn't necessarily been listed.
Well, that fixes if this is the case, you can't do this, but it still seems like kind of a hokey trigger.
Do you want to take it away from the filing entirely and just say if the affiant discovers, well, if property that takes it over the limit?
Well, you know, the more logical trigger point would be that if the affiant discovers
Right,
additional property or discovers that the values are different.
right,
And as a result, you've exceeded the jurisdictional limits, then you're out.
right. So we could tie it back to 6 and say if,
Isn't that kind of what this says though?
well, yeah, but I think John is,
You have to shall file an amended affidavit.
except as provided in sub 7, the affiant shall file, that's what 6 says. So, you could say if, yeah, I don't know, to be listed,
Well,
or maybe required to be listed in the amended, yeah, how about that? If the fair market value of the property required to be listed in the amended affidavit under subsection 6 exceeds the value limitation. So that's a little bit more wordy, but does that express it better? If the fair market value of the property required to be listed in the amended affidavit under subsection 6 exceeds the value limitations.
So, why not have the affiant file?
Well, because we didn't want the affiant to trigger their own termination of authority.
Well, I'm saying, it seems kind of weird to me that the only thing that the public records disclose is a notice with the court that there's no qualification. You got the information, it wouldn't make more sense to file the affidavit and, see the report and add more lingo to it,
How about,
that we don't have, we're over the jurisdictional limits.
Yeah.
Or it's not a small estate anymore, I'm out of here.
rather than, I hear what you're saying, and that makes sense. Rather than make that, give the applicant, though, give them the trigger, to be disqualified by when they file this, we could require that that be included in the notice that they have to file with the court.
Yeah.
So it's not an amended affidavit. We're saying you can't file an amended affidavit because you're over the limits. You do have to file notice of the court, and that notice, we can say you have to list all the property and values that have come into knowledge or possession of the, so it would be what you would put in the amended affidavit, but it's not an amended affidavit, it's just part of the notice. And that's probably useful to a PR or to somebody else as a starting point. You're right.
Yeah, and the applicant has the information.
Right, okay.
So why not report the
Yeah.
information along with the termination notice?
So then, okay, so let's try that. Then 7 would say, if the fair market value of the property required to be listed in the amended affidavit under subsection 6 exceeds the value limitations, you may not file. Then we say, the applicant shall promptly file notice with the court, and maybe a new sentence, that the notice shall include a description of the property and value of the property, whatever we want to say, that has come into knowledge or possession of the affiant. All of the property.
I mean, wouldn't you just, could you list all the property of the estate, or?
With a description of the property, of the estate, and its value.
Yeah, something, that's what we want, yeah.
Where's
Yeah,
the,
pretty basic.
where's the language that we use
Right,
to define what you have to put in the affidavit itself?
that is in, yeah, because that's a good place to go. It's section 7. 7(1)(c) is the description of property and
Yeah,
value.
we can do that from there. Graphic states fair market value and a legal description of
Yeah.
real property.
Yeah. Okay, all right, so that's what they do. They don't file an affidavit, but the notice has to include a description of the property and a value, okay? Then let's go back to, section 13. Sub B, may not commingle property of state, which the affidavit is taken in possession of property of the affiant or any other person. Collect the income from the property of the estate in the possession of the affiant. It's all pretty straightforward, I think.
I have a comment on sub A.
Yeah.
That termination of the fiduciary duty issue. In section 4, sub 7, that we were just looking at.
Yeah.
We do create a duty to deliver the assets of the estate in the affiant's possession upon request by a personal representative. Do we not, I don't know if this is splitting hairs, but we were just talking
Yeah.
about comments to.
Right.
Do we consider that to be a fiduciary duty of that action? The sole remaining fiduciary duty? Once that point has been reached?
Because the request would take place after the notice.
Right, yeah, and probably would, yeah.
Because you
Mhm.
got to file for probate. So
I guess I see the affiant's affidavit liability still, though, then really falling under the probate as opposed to the small estate. But,
oh, I guess I'm not thinking of it being, pursued within one proceeding or the other, but just that the basis of the liability is still that they were a fiduciary who received assets of the
I think
estate.
we have terminated theirs as of, I mean, what we've done now. is
Right.
terminated it.
but yeah, Matt, you're saying that there's one thing that they have left to do. They're required.
That, I mean, to me, that is still a fiduciary duty, because you're holding those, anything that you collected, you're still holding on behalf of the estate, even even if you have no further authority to do anything with it except deliver it to a PR.
Yeah. Well, that's interesting, because I guess you could be a fiduciary with a duty but no authority.
Yeah. I mean, it's kind of like an escrow agent that
Yeah.
to hold it.
Yeah.
Somebody's request.
Do you think we need to state that expressly?
Well, I'm just thinking, I don't know that the statute needs to be changed.
Yeah.
In terms of
The comment, okay, shouldn't be quite as exculpatory.
Yeah.
All right.
Don't want to foreclose.
Yeah, okay.
Really that there is a
So
fiduciary.
we'll make clear in the comment that it's their authority that's terminated, but their duty to deliver the assets to a personal representative, is continues.
Well, and that is also in section 13, way at the end, subsection 4, where it says a claiming successor's personal.
Yes, that's a good point.
accountable.
That's a good point. Yep. Yep, okay, all right, so we're covered there. In sub F, we say, from the property of the estate shall pay these things. Under H, may transfer and sell property that is part of the estate as provided in section 15, we'll get to that. Shall retain records of administration until at least the later of the expiration of the 2-year period under 550 or the conclusion of any summary review proceeding.
I think it's a good thing.
Let's see. Well, let me see. 4 says a claiming successor to whom property of the estate is delivered or answerable. Is delivered, transferred, is personally answerable and accountable. To the extent of the value of property received to creditors of the estate, that's current law. To any personal representative of the estate of the decedent, appointed after payment, delivery, or transfer is made. So that really gets at the, no, that's not the affiants, but I still think we got the affiant covered.
Isn't it asking?
A claiming successor?
Complaint.
That should be a term of art. Description.
Yeah, except this is after payment, delivery, or transfer has been made. I think we're fine. I think we've got it covered. And the comment will indicate that termination in 4 sub 7 is a termination of their authority, not of their duty. And I think we're okay. Okay, section 15, sales and transfers to third parties. Been a while since we looked at that, so let's take this from the get-go. Before completion of the 2-year period, and in exchange for adequate consideration. So this is this is sales. The affiant may transfer or sell any real property if each successor in interest of the property joins in the conveyance.
What is adequate consideration?
Yeah, I was thinking this. You know, it's bad when you're thinking.
Coining a new term.
I did just brief it, actually.
You did? You
Yeah.
briefed it?
Yeah,
Why? It's not law yet.
just statute.
Oh.
That the statute that provides for the transfer without adequate consideration
Oh.
may be voided.
Okay.
There's dictionary definitions and, both Webster's and Black's laws make a distinction between, adequate and sufficient.
What?
And sufficient, I believe, was simply really necessary for, enforcement of the transaction, but adequate carries some connotation of fair market value. But if we want to be more specific, I think being more specific would probably be a good thing.
How would we include fair market value in that sentence?
Substitute fair market value for adequate consideration. In exchange for
Before
fair market
completion and in exchange, and for fair market value?
And we've defined when fair market value.
Yes, we have.
Right.
Right.
Oh, that's not so good either.
What, for fair market value? What? Yeah, tell me.
How do you define it?
Yeah, well, and also, I suppose one of the transferee might be a beneficiary who's buying it and applying their share
Yeah.
against the purchase price, and so,
It doesn't have to be,
I don't know, maybe adequate consideration, and.
We have a lot of that. But it's-
Do you?
Fair and adequate. Fair market value is, something that establish that in appraisal.
Hmm,
And the value that two parties.
yeah, I don't think it requires,
And the appraiser predicts.
Yeah.
but you don't need an appraisal
Right.
for fair
But you
market.
have one,
You-
maybe you have
common
one.
comp.
Maybe you
Yeah,
have
right.
one, use that to establish the value of the affidavit. And then you get a real buyer
Right,
and a real
right,
seller,
right.
and the number is different.
That's
than
right.
what the appraiser predicted.
yeah,
was
right,
gonna be.
right,
Well, that just proves that the appraiser's not God.
right, right. So, you're saying fair and adequate consideration?
Or just, well, I don't know.
Or what about
Do
adequate?
we have adequate defined anywhere?
Well, we certainly put in the comment, and,
It is a statute already.
but yeah, Marissa's saying that adequate occurs in the statute.
And we also have fair and adequate. Oh, here's for fair market value and adequate consideration.
Oh, wonderful.
Yeah,
It's just like intentionally making different language.
And that is, I mean,
Well,
that's,
fair market value and adequate.
This one is
the worst.
actually-
I was gonna say, it should be and or.
This is.
Right, those are actually-
you get to choose whatever goes
Whatever
down.
that shows up, we need to change.
This one is in good faith in an arm's length transaction and for fair market value and adequate consideration.
Well, that was a committee that could not make, that was a committee that could not make up their mind. I think adequate consideration with a comment that picks up, Matt, if you could send, some of your briefing, to Sandy, then we can pick that up in the comment for what adequate consideration means. I think it's a good enough signal.
So where's the statutory overload that you found?
That's all over the place. There were lots of statutes, actually.
This one is, 311-235, a bona fide purchaser when taxes become a lien without
Oh,
real
tax statutes,
property,
yeah.
yeah. This
You know, let me check
It's old,
and see
it's
if
very
there's
old.
anything on anybody's done any research on that.
Well, Matt just said he did. Yeah, if you could get,
Other, if we,
okay.
there may be, with regard to some of the
More better.
More better. Okay, well, let's go with adequate
You
and,
know, let it out, those are long-
let's go with adequate and if you've got something, send it to Sandy so he can get it to Susan for her comment to further explain what adequate means. Okay. The affidavit may sell or transfer any property, if the real property, if the successor in interest in the property joins
So
it
we use fair market value.
for the valuation in the affidavit.
Valuation to qualify.
Right, right.
So I think probably we need to explain the difference.
Well, the comment will.
So what is, the term successor in interest? That is not, is that just a claiming successor?
Actually, that's in the current statute, isn't
Yeah.
it? It is in the statute currently.
It's defined,
Oh, it is?
yeah.
It is?
Who said that? Where is it defined?
In 114.505.
114.505.
It says section 1, if the decedent died intestate, the heir or heirs of the decedent, or if there is no heir, DSL. If the decedent decides, why can't I?
Wait, that's claiming successor, that's not successor in
Oh,
interest.
successor in interest. I'm
Right.
sorry.
Successor in interest to the property, we know what that means, don't we? Somebody who's gonna get the property?
But this is the smallest state affidavit.
Right.
And it's gonna be a layperson who's,
Well, good luck.
are they gonna know to go to comment for adequate?
No, but the court
consideration?
will when they get in trouble. Yeah.
Successors in interest.
Could we just call it claiming successor?
No, because it's gotta be particular to that piece of property.
Oh.
So you may be a claiming successor, but not of that property.
This was if the will gives item X to Joe, and Joe's the only one that has to sign off on it.
Right.
Right.
So, the claiming successor,
Is there somebody on the phone, or is that Clackamas County having a caucus? Oh, okay.
It doesn't appear to be in there already.
Oh, no, yeah, but I think we know what successor interest in property, don't we? Don't we?
I think
I do. B, the affiant may transfer or sell any personal property that is specifically devised to an individual beneficiary with the consent of the individual beneficiary. C, let me get through this. The affiant may transfer or sell any personal property that is not specifically devised to an individual beneficiary without the consent of any other person. So as I see it, we have real property. If real property is part of just the residue of the estate, if it just says, to my children in equal shares, and it doesn't specifically identify the property as an asset in the will, then those children, or if it's just, again, part of the residue, those residuary devisees are the ones who have to consent to a transfer of real property. For personal property, consent is required if the personal property is specifically devised but not otherwise.
So we still haven't fixed the current which is where you.
Oh, just a second, John. Just, on the phone, whoever is doing keyboarding, we can hear that pretty clearly in the phone. If you could keyboard just a little softer, please.
Sorry, that was me. I'm muting myself.
All right.
So if you just cannot administer the estate without selling the real property, you still need all of the beneficiaries to consent to it.
Wait.
yes. If you need to sell the property, everybody has to sign off, yeah. I mean,
It's under two.
Yeah.
No, well, the real property, sorry, John, that's not the real property. And I think that our discussion was just that that's maybe
The way we want it, I guess.
too big of a item to entrust the affiant
Yeah.
to do on their own.
That was, I think, the conversation. And I think we also said that if you've got a recalcitrant beneficiary, the affiant themselves can file a petition for summary review.
Yeah, if you have somebody that won't.
Right.
Agree.
And then that's right, yeah.
You ask the court to give you the authority.
Right,
Yeah,
right.
there.
Yep, that was the conversation.
Okay, that's good. I'm good
Okay.
with that.
Number 2, section 2, notwithstanding sub 1, the affiant need not obtain participation and consent if a transfer is required for purposes of abatement under 116(133). 3, the proceeds of sale, net of the reasonable expenses of sale and any debt secured as of the date of the decedent's death by a duly perfected lien on the property, become a part of the estate. 4, so that means if it's a mortgage, it gets paid. If it's a judgment, the judgment creditor is just a general creditor of the estate, right? And not a, or are they a lien? Yeah, I guess they are. Oh, that's right. The judgment was entered before death. That's right. That's how it works. If the judgment was established as a lien on the property before death, then they are a lien creditor. If the judgment is entered after death, then the judgment creditor is a general creditor. Okay. 4, if the affiant transfers or sells any vehicle, affiant shall comply with the Department of Transportation. Same thing for in 5 for a manufactured structure. 6, any transfer or conveyance to a purchaser in good faith and for a valuable consideration.
Love coal.
Let's try this again. Any transfer or conveyance under this section to a purchaser in good faith and for a valuable consideration transfers or conveys the interest stated in the transfer or conveyance free of any interest of the claiming successors and the purchaser has no duty with respect to the application and consideration paid for the transfer or conveyance. Shall we just change all that to adequate consideration, if we're gonna use adequate consideration? Yeah.
That does sound like something that is already in.
It probably is.
I mean,
Should
most of
we
it,
check? Okay.
well, not most of it, some of these were just copied from
I doubt it.
somewhere current,
Current law.
Usually.
but,
Yeah, but let's use adequate consideration since,
I think that's
yeah.
okay. Unless there's some case interpreting that or something.
I have,
Well, do we need transfers or conveys? Are they the same thing, really?
We have transfer or
Well, we
sell
have
up
transfer
here.
sell.
Yeah, okay, transfers or sells.
Yeah, that's what we have, a transfer or sale.
I mean, okay, even back to that.
I mean, you're doing it for adequate consideration, isn't that basically
A
a sale?
sale, yeah.
Any transfer under this section?
No, you don't necessarily convey personal property, do you?
I don't know, that's an interesting question.
Well, and up above, we're using
Or you have transfer or sell everywhere else.
Yeah.
Yeah, okay, let's say transfers or sells
Yeah,
then. So it'll be
yeah.
any transfer or sale under this section to a purchaser in good faith and for adequate consideration. I would just say transfers. I don't think we need or sells there. Transfers the interest.
Stated in the transfer.
So is sale made under this section? It's made in, it's allowed by this section, but is it made under this section?
Yeah.
Yeah, because this section, to get the protection of this, it's gotta be for adequate consideration under one, it's got to have been with the consent of the successor in interest if it's real property. So I think we do want to tie that made under this section, so that if a sale occurs that does not comply with the conditions of this, then I think the BFP doesn't apply. Okay?
I wanna raise something to talk through, just to make sure that this is how we want it. Back up in one, on this adequate consideration issue. I think clearly if, the applicant is selling this to a third party, because they want the cash and they're gonna distribute the cash.
Right.
That's exactly how we want it. If the purchaser is one of the heirs or devotees.
Right.
That will receive it, and so take something simple, there's only 2 heirs or devotees who would receive the estate, and there's one claim for $10,000.
Correct.
You only need to, and the estate's gonna be divided equally, you're gonna only need to pay, the purchaser really only needs to pay
Half.
50%
Yeah.
plus $10,000.
Right.
Do we need to account for that in some way, or is there a different way that transaction occurs?
Yeah, I don't know they need to get that granular. Bottom line, creditors have to get paid.
I mean, it's gonna be, in theory, should be a no harm, no foul.
Right,
Nobody
right.
should really have any concerns about it, but if we are preventing it here, I don't wanna necessarily create an issue for somebody.
I don't think we are. At least speaking generally, I think adequate consideration sort of leaves that open.
Adequate because that's all that was needed in order
Yeah,
to pay the
yeah.
interested party.
I mean, bottom, and it's elsewhere in the statute. I mean, creditors come first anyway, so, you can't have a sale here that, prejudices creditors.
And I guess that would be the remedy.
Yeah,
If the creditor or the other heir has not gotten paid in full, then they could file a PSR and they would say, no, this didn't apply because that wasn't adequate.
yep.
Okay.
And the claiming success, if you're selling to a claiming successor who's paying only part of the consideration and receiving the other part as an advance of their share of the ultimate distribution, then they become liable under Section 13, page 12 at the bottom, there the claiming successor personally answerable, accountable to the extent of the value of property received to creditors that are entitled to payment. So I think we've got them, I think the creditors are covered. All right,
So can we go over the wording of 6 with the
Yep.
sale and transfer?
okay.
Because it's,
Oh, okay, so what's it gonna be now? Any transfer or sale under this section to a purchaser in good faith and for adequate consideration transfers the interest stated in the transfer free of any interest of claiming successors, and the purchaser has no duty with respect to the application of the consideration paid for the transfer or conveyance. Sale. Okay,
Do we need transfer?
Yeah, I wonder about that. We have, so we could take it out throughout because we've got transfer, or sell. I don't know, what do you think that means? Are you not really selling it? If it's an exchange, what is it, like an exchange?
Yeah, to me, transfer means something that may not necessarily require any
Right.
consideration. So, yeah, I think you're kind of muddying the water
Yeah.
by putting that word in there instead of just saying.
shall we go with conveyance or
Well,
for sale?
can be the same thing.
well, but you could have a situation where the real property value is the equivalent to the mortgage, and you just need to sign off on that. Something like that, where it's not a sale,
Yeah.
but
I'm okay with transfer or sell, I think. I mean, the conditions are what's important. Let's stay with transfer or sale. Okay, section 16, liability of the affiant. What? Damn it.
Just to show you I'm listening to you.
We know, John.
Reasonable?
No. You're transferring the interest stated in the transfer free of any interest. The transfer is the act of transferring ownership to somebody. It's not necessarily a document.
All right.
Something stated in the transfer.
Do we need to say that at all?
Only stated in the transfer
Can we-
documents, and you got personal property here, which you can transfer without a writing. So how do you
Okay.
counter that?
Can we just say transfers the interest free of any interest?
I think so, yeah.
Claims the interest, yeah.
Yeah, I think so.
delete.
Get away from state, yeah, right.
The interest, transfer the transferred interest free of.
Yeah, because you're right. Personal property might be a bill of sale, might not, who knows? Yeah,
That seems like extra work.
it does. Okay, good. Transfers,
We should require bills.
yeah.
We want fees for everything.
All right, let's go to section 16, liability of affiant. An affiant may be liable for and is chargeable in the accounts of the affiant. What does that mean? With, 1, all of the estate of the decedent that comes into possession of the affiant at any time, including income from the estate. 2, all property not a part of the estate if the affiant has commingled the property with the assets of the estate. Or B, the property was received under a duty imposed on the affiant by law in the capacity of affiant. 3, any loss to the estate arising from neglect or unreasonable delay, neglect in paying over money to living property of the estate, failure to pay taxes or close the estate. Let's flag that. I'm not sure that do we close a,
Well, we moved to close it, right? It's not always, or is that in a different one?
D, embezzlement, commingling with other property, unauthorized self-dealing, any other negligent or willful act. Okay. Let's go back to, what does it mean, in the very beginning? An affiant may be liable for and is chargeable in the accounts of the affiant.
Wait a minute, go back up to C.
Wait, I've gone farther back up than C. I'm at the very beginning of 16. Affiant may be liable for and is chargeable. Do we need in the accounts of the affiant? I'm not sure what that means.
This
Let's
is language that we took from the
Yes.
statute that relates to the DR. So
Yeah.
Oh,
if we make a change here.
okay.
we wanna make-
Oh, it's in chapter, yeah, it's in 116 or, what, no, where? Okay, well, if it's,
Yeah, but the affiant doesn't have any duty for accounting, so maybe it's just,
Use the same gibberish twice.
you're right, maybe it's just maybe liable for and is chargeable with.
Oh, maybe the accounts means, yeah, accounts that a PR is filed, which we don't have here. Is that what accounts means?
So what section is this language from?
116.063.
Chargeable in the accounts, could that mean?
And that's under the accounting and distribution statutes. So
we
accounts
left
there.
this in there for the regular probate.
Yeah, I think so. I think accounts doesn't belong there, because I think accounts there is talking about something, it's not talking about the bank accounts of the affiant.
Oh, in the account, I see,
Yeah.
Okay, what, can we just say maybe liable for?
Yeah.
Do we need this, is chargeable in the accounts, is that,
I don't think so. I think that deals with accountings.
okay,
An affiant may be liable for it,
Yeah,
colon.
yeah. All the estate of the decedent that comes into possession of the affiant at any time, including income of the estate. 2, all the property not part of the estate, if the affiant has commingled the property with assets of the estate, or the property was received under a duty imposed on the affiant by law. 3, any loss of the estate arising from neglect or unreasonable delay in collecting the assets, neglect in paying over money or delivering property to the estate. John, this
Before
is,
we run too much further past this whole chargeable thing,
but,
looking at the statute, the rest of the statute that has that and the other places, the chargeable is being used in 116. 083 starts talking, 116.083 starts talking about the property that the personal representative is chargeable with according to the inventory. So is that a reference to what we're charging the PR, or in this case, the affiant, with being responsible for, and in which case we would want to maintain that reference?
I don't think so, because as we get in the itemization, it goes beyond property in the affidavit.
Okay.
Yeah. No, it's a good question, yeah.
Meaningful reference, I want to make sure we're not.
No, that's a good point. But since the itemization includes property outside of the affidavit, I think we would not want to limit it to that. John, we were just getting to 3C, and you had you wanted to comment on that?
I've had a lot of the states that fail to pay their taxes as required by law. And, do it all the time.
Because of cash flow?
There's no money.
Yeah.
And if you told the Department of Revenue to stick it more than once.
Mm-hmm.
And they say, well, you owe it, that's what the law is, screw you, try and get it.
Yeah.
That's not something that affiants should be obligated on.
Okay, that's a good point. Do we qualify that with, to the extent of assets available?
well, any loss to the estate arising from that, so if you're not required to pay it,
Exactly.
then you don't have any loss.
Pay it, you don't have the money.
Oh, okay, because that's true. It's not saying you are we're not creating personal liability here
You're not creating.
for taxes. We're just saying you're liable if there's a loss to the estate. So what does that mean then?
Well, so it means if you're late or don't file taxes,
Oh.
there's interest or penalty.
A penalty, okay.
You're liable
All
for
right.
penalties, I would think.
Okay,
There, my one caveat to this is that we see this a lot, is they haven't paid property taxes and the county is moving into foreclosure and the real property is in jeopardy of being lost because of inaction. And you can't, if you tell the county to stick it, they're just gonna go ahead with their foreclosure.
that's true. The county has recourse that Department of Revenue doesn't.
So that would be a loss to the estate as well.
But
Yeah.
if there's no cash to pay it,
Well, then they gotta sell it or they borrow money or something, but
okay,
I don't want them just sitting around on their hands and see people do that.
okay.
Well, if you add neglect or unreasonable delay to that, it fixes it.
Kind of like adequate consideration with unreasonable delay.
Well, we end that section, or close the estate within a reasonable time. Does within a reasonable time modify pay taxes as well as close the estate?
Well, I wouldn't
There's no
say so.
comma, but yeah.
Yeah, why are those two things together anyway?
Yeah, those should be
Yeah, that's
separate.
Should be separate.
Okay,
Failure
that's a good
to-
point.
Yeah.
But I violate the obligation to pay taxes all the time.
Okay, but it may not cause a loss to the estate if you don't have cash to
Well,
pay
yeah, it
it.
does, you have the interest and penalties.
Well, but not if there's no property of the estate, if you don't have cash to pay it.
Well, if you got real estate, you
Yeah,
got assets, like I got an $8 million estate, and we can't pay our Oregon income tax. and.
Well, are
if
you
they
not,
already say that.
not paying, and maybe that's why it's within the delivery of, in the closing of the state is, maybe that's why that is there, is it's not that it's like during the process, it's at the time you close it. At that time, if you have $1 million house, you sold it, you should have the money to pay the taxes by that point. I think that's maybe what that's supposed to be meaning, is that you have paid any taxes due because you have the money to do it. If you're in a situation where you're in a state where it's insolvent estate and there's not sufficient money to pay federal taxes, for example, then.
Because that's one of the elements in your final accounting is to declare that you have paid.
Yeah.
taxes.
Yeah, so I'm guessing that's why those two things, the closing of the estate within paying taxes, because, yeah, maybe along the way, those taxes become due, and you're saying, I'm not paying them because I haven't been able to sell the house yet, and so they accrue, but you haven't not paid them until everything's closed, and then you don't pay them.
But could we say it this way then, failure to close the estate and pay taxes as required by law within a reasonable time?
That makes, I mean, I think that reaches what that is trying to get to, much.
And do we want to qualify failure to pay taxes subject to the priority statute? Which,
And why do you treat taxes differently than?
well, that's a good question.
Because that's like I
I'm
mean,
more
that subjects people to real criminal charges too. Failure to pay taxes,
Well,
tax evasion.
I'm not worried about that.
Does the affiant really have the obligation to pay taxes of the estate? In its bare bones, John, you keep making the point throughout the last 2 years, that the affiant just signs a document that says these assets go to so-and-so.
Yeah.
And
there's, by definition, there's no state tax.
Right.
any taxes that would be, any real property taxes that were owed would follow the property and be the obligation of whoever received it. Any,
But what about the decedent's, unpaid income tax?
personal income tax.
Right, I mean, the affiant has to be responsible for that.
I've always
Someone
treated
else.
the affiant, regarded the affiant as responsible for.
I'm more worried about the consequences of this language in the chapter we took it out of.
Yeah, really. Wait a second.
Yeah, I don't care about this. Where'd it come from? That's where the problem is.
We need to look at that one
It's
again.
a source problem.
You have a personal representative who has an illiquid estate and has no practical alternative other than to go in default
Right.
on the tax obligations.
Or borrow money.
And you can't do that if it's illiquid,
Yeah.
because you're not gonna be able to borrow it. You can't sell the asset without.
I think the answer there is there's, in those cases, there's no loss to the estate on a case.
The interest and penalties.
Well,
Well, maybe this comes back to Gigi's suggestion about reordering this. If it said failure to close, I was thinking slightly different. Failure to close the estate within a reasonable time, including by paying taxes required by law, because that's, in my mind, the accounting statute requires that the PR
Right.
declare that those taxes have been paid.
Well, but that's not how it works, because, when you close a probate,
Right.
you say all of the taxes until now have been.
right, yeah,
And
because
then
there's an
you have-
obligation that follows,
Right,
yeah.
and then you get your judgment, you get your receipt, sometimes you file your supplemental judgment, and then that tax return is filed afterwards.
Yeah.
And so, that process doesn't really work.
I don't see why the two concepts of paying taxes and closing the estate should be in the same sentence.
I guess the other thing to do is maybe, do we need to, we've got under F, any other negligent or willful act or nonfeasance. Does it confuse things to call out taxes there? And just say if you had to close the estate within a reasonable time and can't close the estate until you've paid creditors, then taxes are
Taxes are one of the
things you have to pay.
Yeah.
And it all comes under the priority statute without having, maybe we do that.
So take out, the taxes
Yeah,
and,
Gretchen, can you live with that?
Yeah, I'm with that.
Okay.
and the closing.
Wait,
No, well, I think failure to close within a reasonable time, yeah.
Yeah, that's a different concept.
Right,
Failure to finish the job.
Yep.
That's okay.
but we have somewhere else this duty to pay tax. I want it just to be clear to the applicant that they have to pay tax.
well,
So that's someplace else, under,
Is that in the thing
Well, they
about
do,
the?
they gotta pay the decedent's pre-death income tax.
so that is,
those are,
where is that? I want it to be stated.
Well, it needs to be in the obligation.
That's not in here.
So like on section 13 is kind of where it lists all of the applicant's obligations.
Yeah, that'd be a better place.
And so maybe we put it there.
So
Why don't we just pull the language from 116A? You know, it says the taxes, have been paid or if not paid, have been secured or otherwise, provided for.
So the accounting statement that we have to do.
Yeah.
so that would be failure to pay,
I think it would still make more
No,
sense in
I-
13.
But-
Or if
oh.
not paid, have been provided.
okay, to put it in 13.
Put it in 13.
Right.
Yeah, rather than, it's
Yeah.
the negative, rather than in the negative, make it an affirmative duty, pay taxes or secure and pick up the language there.
And then we don't get into this idea of loss from.
Right, right. That's just, yeah, okay.
Is this the statement that all Oregon income taxes that are due
Yeah.
and paid, that's this thing?
Yeah.
All tax returns been filed.
Turn that into an affirmative.
Yeah, that's right, yeah, and put it in section 13. Okay,
So
that's good.
So
what's
then,
missing here in 16,
Wait, so first of all, we're taking failure to pay taxes out,
yeah.
right,
because that's just one of the affirmative things they have to do. Okay, failure to close, so what, John?
So I think you fix the taxes by putting that in 13.
Yeah,
But what's still missing is, failure to get the debt paid in a prompt manner.
no, but this is any loss arising to the estate from,
So
so,
we got collecting assets, paying over money or delivering property in the estate. I don't know what that means, but I don't think that means paying creditors.
Why don't we say to administer and close the estate?
well, we do have under F, the catch-all, any negligent, willful act or nonfeasance in the administration of the estate.
Yeah, so, I mean, you could use that, if you've got creditor claims and you just blow them off.
Right.
You get big penalties assessed because of that, that should be chargeable.
And I think it is under F, if it causes a loss to the estate, and it very well could.
but we talk about
But if we're
creditors.
pulling things out separately,
Right,
either we make F the entire section,
uh-huh,
or I think
Oh.
creditors make sense as a thing to pull out specifically.
I
yeah,
agree. If you could say something like failure to pay creditors to the extent of the assets of the estate, which is kind of how it's qualified throughout.
I guess, yeah, I like F, I think I like the catch-all, but I also like the clarity of some of the specific,
Right.
Well, then what do you need
So-
D for?
huh?
What do you need D for?
B, D?
B,
Neglect in paying over money and delivering property to the
Yeah,
state.
so I
Oh.
What does that mean?
yeah.
That's a good question.
Maybe that's where we put creditors.
Yeah. Well, but
Wouldn't that also be aimed at failure to distribute?
Yeah, but isn't that kind of,
Appropriately or whatever?
well, maybe what we do there is in C, failure to close and distribute the estate within a reasonable time, because that really, that's what has to happen, you close and you distribute. Or distribute and close, I guess, is the order.
How do you
And like
close it?
Kathy's language earlier, administered and closed, because that gives you room.
Right.
Slightly more than just-
But I raised the question about close, is close the appropriate?
No, it's.
No, it's not.
No.
Close the smallest.
Yeah, we're not,
Just say distribute.
yeah, failure to distribute the property of the estate within a reasonable time. Yeah,
So are we gonna add in there like a new number 3,
Failure to pay creditors,
Paying the
failure to pay
creditors.
creditors to the extent of the assets of the estate.
Right.
Yeah. Let's do that let's make that B, because I don't think any of us know what neglect in paying over money or delivering property is.
But
And then we
that's-
can pick that up in C, failure to distribute the property of the estate within a reasonable time.
But your 3 is relating to a loss to the estate.
Right.
And it's a more fundamental thing of you failing to pay the creditors when there were, assets. That there may, that's not really a loss to the estate, you just didn't do your job. You could be liable for not doing that. The creditors could come after you and say, okay, I want my money. And that's not because of a loss to the estate, that's a separate thing.
Yeah, aren't you already liable for not paying creditors?
Well,
I guess that-
I think the question comes down to who is liable, and right now, the summary review statute gives the court the option, and I think this is.
Well, that's a good
this
point.
should be reflected here, to charge
Yes.
the affiant with that debt, if circumstances warrant. And
Uh-huh.
I mean, that, you have to, the statute as currently written is not explicit about what those circumstances be, but it says it can, order that the claim be paid from the affiant or from the recipients of the assets of the estate, something to that effect.
So that's what happens.
That chargeable language came from, at the beginning of this section, we were wanting to make it clear that the affiant wasn't just liable as an affiant, they were liable in their personal.
Well, then we could put personally liable, individually liable.
Yeah, I think we gotta look, what's the purpose of the section, liability of applicant. So if we're gonna, do that, then I think, and again, I agree, non-lawyers are maybe looking at this, giving them, okay, what's my liability? Okay, I'm looking at this. Maybe they don't understand all the terms or something, but basically, if it's listed out, that's gonna be a lot more informative, I think, than to not have it and just say, well, they should know.
So say, an affiant may be personally liable for.
Right.
I think so.
And see, the other thing is, if this is from the probate process,
Person is defined to include,
if this is from the probate process, part of the probate process is if there's an unpaid claim, the court can just say, no, we're not closing this estate, whereas this, there's no supervision, So I would add a new section 3 that would say, an affiant may be liable for not paying any creditor to the extent of the estate assets, or something consistent with the other language that we've used. And then have any loss would be number 4.
do we need a crosswalk though then to summary review, because the court can also impose liability, they can charge back assets that have been distributed to beneficiaries.
But
So-
this is about the liability of the affiant.
Right.
I mean, we could just put amounts charged under.
Yeah, I suppose so. I don't know, we may be complicating this more than we need.
Well, I mean, that's the problem with this whole process. It's
Yeah.
complicated and.
I'm actually, Jennifer, I'm kind of circling back to where you were, making 3, just any loss of the estate arising from any negligent or willful act or non-fee since the administration of the estate.
Yeah.
It is nice to have the embezzlement and the commingling, I mean, those are some good examples.
Well, and failing to distribute the property.
The summary review options are a protection for creditors.
Right.
Among others.
Yeah,
I mean,
but also beneficiaries.
I've had at the estate where the affiant got the bank account distributed amongst herself and 2 other siblings. And then I, as the creditor who didn't get paid, have to then file for summary judgment and ask the court to order each of those people to reimburse the amount, or should I just have the right to, I mean, in fact, this one was, the funds were distributed before the 4 months were up. I feel like I should have the right to say, affiant totally did not do their job, and so should be liable directly for, I don't know, gross negligence in administering the estate. You didn't do anything to try and pay claims, and me as a creditor, I shouldn't have to chase after everybody who got assets. You as the affiant had this job to administer it, and so this is what Jennifer was pointing out, that paying those claims is a duty of the affiant. We're creating that duty here.
Well, that's already created in 545, section 13. The duty is already created.
Okay.
This is
Well-
Rita. Shouldn't you be able to chase either the people who
Yes.
receive the asset or the affiant, whoever has the deepest pocket?
I think so.
Yes.
So by making the affiant liable, we don't want to exculpate the,
Right, but right now,
beneficiaries.
this language doesn't actually make the affiant liable, because it simply says free as any loss to the estate.
yeah.
There, I mean, I guess, if the assets are still recoverable from the heirs, then arguably there was no loss to the estate, and that's what I think Jennifer was suggesting, a new number 3, this 3 becomes 4, new 3 is simply that the affiant is liable for failing to pay claims, because that's their job, is to get these assets and then use them to pay claims. And if they skip that, then the creditor should have the ability to go to the court and say, affiant didn't do their job to pay my claim, they should be liable for the claim. And if the affiant has some remedy to, try and seek assets back from whoever they distributed it to, then so be it. But if they don't, then that's the duty that they took on.
or if we take out to the estate from sub 3, it's just any loss arising from. Could we lump all these things together? I mean, the loss to the estate seems to be sort of hampering us in how we use this subsection. And maybe if we take out loss to the estate, just say any loss arising from, and then we just, it could be a creditor's loss, it could be a beneficiary's loss, it could be, any loss.
Is your situation not covered under 1? If you've improperly distributed property of the estate, then you'd be responsible for paying it back?
What number 1?
Section 16?
Yes.
Section 1, we deleted the definition of estate.
No, 16 sub 1. But what do we think about taking out any,
No, but the problem is we're referencing an estate in 16 sub 1, and John's saying that we undefined estate.
In section 1 of the bill, 114.505 sub 3 defines estate.
yes,
And we deleted that.
I think we deleted it because it's defined in 111.
yes, that's right, right,
Oh, okay. All right, so we still have a definition.
Yes.
So then what's wrong with using the word estate?
in 3,
Yeah.
any loss to the estate. Well, I'm just thinking, okay, then we do need a separate section if we're talking about creditors.
So the idea of taking to the estate out was so that if Matt gets screwed, Matt can still be covered under 3.
Right,
Or if it's the beneficiary that gets screwed, not the estate.
right,
I think it makes sense to just cut that to loss arising from.
it does to me, then it's just,
Otherwise, that gives you some really weird wiggle room for
uh-huh,
unscrupulous attorneys not in this room.
yeah, right, yeah, not in this room. But the unscrupulous ones in this room.
Be careful.
How about that? If we take out loss to the estate, any loss arising from neglect or unreasonable delay, whoever is damaged by it. Neglect in paying over money, failure to close, to distribute and close the estate, failure to distribute the estate within a reasonable time, and add in failure to pay creditors. Claims of creditors subject to, to the extent of assets, the assets of the estate.
Right. So then do you think?
How about neglect or
Then it covers the
delay?
Okay, all right.
Right. Because the neglect of paying over money, that would be paying.
So
We get rid of this dang over money.
Right.
Yes,
Right. Okay.
What if 3 says any loss to a creditor, heir, or debtee?
or,
Why do we wanna specify it? Why are we trying to exclude people from this loss?
I think the only people trying to allege this are gonna be creditors or beneficiaries, right? And we don't want them trying to prove loss to the estate necessarily.
right. I suffered loss, yeah.
We want them just alleging that the affiant did something wrong, and this is my basis for trying to challenge that.
Okay, so, yeah, but we do want to caveat it a little bit, I guess, then to the people that we care about, and that's creditors, heirs, and devisees.
Well, and then if you take out to the estate, then sub B, neglect in paying over money or
Yes.
delivering property, that would apply both to creditors
Yes.
and devisees or beneficiaries, right?
I think it would.
But that's a loss resulting from it, and I guess what okay, so that would be a loss to them.
Yes,
That's a loss
Yes,
to a creditor,
right,
a loss.
right.
Then that should address the problem.
Any loss to a creditor,
Subject.
what?
I don't think we need to give creditors greater rights than they already have under other parts of the law. You know, if a creditor doesn't get paid.
Well, that's
But
okay.
it's qualified as says may, an affiant may be liable for.
Well, I
So-
changed that because it says
Oh.
an affiant is chargeable in the account, so I thought,
But under a summary review, then the affiant may be personally liable.
Right, but that comes under summary reviews. The question is, do you need it here? And does this somehow suggest a broader liability than what,
It would.
yeah,
Creating a different right of action.
yeah.
On the part of the creditor.
Yeah, that's an interesting question.
well,
I
I'm
don't
wondering if
know,
this
because-
neglect in delivering property is like, I was supposed to deliver it and I left it on somebody's porch and it got stolen. I mean,
It
that's
could,
not
it could.
I mean, when you think about this, it's like, I don't see where it creates more liability. This is an informative section for the layperson or lawyer looking to see, what are my potential liabilities? If I'm a creditor, I know I am, then I'm looking at this going, okay, yeah, but what are my mechanisms? I don't have some independent mechanism under this, I have to go to some review. That's my only mechanism.
Then, if that's the case, then the reference to creditors, liability to creditors really needs to,
Liability creditors, as established by court order or something. I don't know if you wanna go there, but this is just kind of saying, all in one place, everyone, these are the potential places where it could be.
This is not a manual for a affiant, this is a statute.
yeah.
And you create legal rights and obligations, and.
This doesn't create any new legal rights.
It would, if you had.
What would your
creditors-
mechanism be to
If you
get
had
that though?
If you add this concept of any loss to a creditor from a negligent administration of the estate, then that's a whole new barrel of claims of creditors.
So creditor files a claim, affiant disallows it, maybe wrongfully. Creditor doesn't file a petition for,
They don't file a petition.
right, does this give them another way to get it? Cause I suffered loss because he denied it.
It gives them a right to recover consequential damages when they wouldn't have it otherwise. It gives them all kinds of rights.
I'm
Yeah.
not getting that out of that.
No, I understand.
I couldn't
I would
find that
have
out.
plaintiff's lawyer.
Yeah, because this says may be liable for, and this is a statute different or other than the claim statute and the summary determination and petition for review statutes. So it must mean something other than summary determination and petition for review.
is that what the chargeable in the accounts is supposed to be taken as?
Well, but it's not the right language.
It's not, but is that where we would put, and you can enforce this through whatever proceeding?
Well, I guess then I could say as a creditor under F, any other negligent or willful act or non-feasance, I'd say that's, you weren't, it resulted in a loss to the estate, you weren't able to pay me because of this, so now I have action under this statute, under that subsection.
So it actually says 5 weeks lost to the estate.
Yeah, but
Boy.
because of the loss of the
Right.
estate, then you couldn't pay me.
Okay, we don't have 6 months to work this out.
Well, so, you know
do-
what, actually, if you look at section 17, which is the summary review
Right.
of administration.
Right.
And you look under 3A, it does give the court the ability to have the creditors paid from the estate or from the affiant.
Yes, right,
So that
Right.
right is there.
right.
And so maybe what we could say, again, because part of our audience is the lay people, is something about refer in this statute to the remedies provided in section 17. May it be liable for, and all the remedies provided in section 17, then we don't have to refer to creditors and.
Well, I think we wanted to add this liability of the affiant to make clear that they are a fiduciary.
Which we've got under section 13, including commingling.
Yeah, maybe we don't need that.
Maybe we don't need
I think
this.
it's maybe like,
I think
somebody's
this,
gonna try to work
again,
it
if we
out.
had 6 months, I might be inclined to try to work it. I'm almost inclined this one just to take this section out. Because the duties are all are everywhere in the statute.
And we tell them back in, what was it, 13, that they are a fiduciary.
Yes.
with duties to
Yes.
accomplish all of these things.
And they may not
can't
commingle.
Yeah.
Take control, collect the income. Yeah,
Well, but what if they are negligent and their negligence causes a loss to the estate?
then you've got a
Does
claim.
the PSR allow that?
Huh?
Does the PSR allow that to be fixed?
Yeah,
The court's reviewing administration.
right. Let's take it out. I think we just don't have time to work out the details. It's a good idea, but we're getting high-centered here without the time to fix it.
Can we fix 116,063?
116.
Stop it. I'm taking 16 out. A victim of the
That's
clock.
on the last list for like 2025.
Okay, now to section 17.
No, so if we fix 116,063, that's where this language came from.
Well,
Well, that's not what we're doing right now.
yeah. We gotta finish this.
So section 16 is gone.
Section 16 is gone.
Okay.
So now we're at section 17, the new section 16. Well, I'll continue to refer by the, okay. So this is, summary review. This is the affiant or any claiming successor, okay? So anybody can file, that's all current language. B, notwithstanding paragraph A person may file a petition for review under this section. Oh, yeah, that's right, okay. So section 1A, paragraph 1A says you have to file it within 2 years. But B says, notwithstanding a person may file a petition for summary review for the purpose of compelling the affiant to distribute the property of the estate within 60 days after completion of the 2-year period. So that's if the affiant hasn't distributed the property. We're giving an extra 60 days there at the end of the 2 years to compel distribution.
And that's probably because somewhere we have that obligation to.
Yes, distribute within 2 years.
By the end of the.
Right, right. Okay, then we have a creditor. That's, sub C is fine with, and then 2, within 30 days after filing a petition, the affiant shall file with the court an answer to the petition. That's new. Then we go down to 4B, upon the hearing, if the court allows a claim of a creditor in whole or in part, the court shall order the affiant to the extent of the property of the estate allocable for payment of the claim. Good, we got our priority statute in there. And any claiming successor to a property estate has been delivered or transferred to the extent of the value of property received to pay to the creditor the amount allowed. Would it be shall order or may order?
Well, if they have allowed it.
Shall, okay. Oh, you're right, because the predicate is if they've allowed it. Yeah.
Well, actually, though, that, first phrase needs to be changed, because the summary review is not the process in which a court is allowing
Oh, yeah, it's not allowing a claim.
That's true.
That's already been done. in-
So it maybe if the court has allowed a claim of a creditor under,
No, because you've already, this isn't, the claim's already been either allowed or not, you know.
Oh, yeah, I was
not
saying-
even disputed, this is, I haven't been paid, so if a court,
oh yeah, it wouldn't come under 4.
yeah, it's not really a claim of the creditor in, I mean, it is a claim that they're brought in this particular proceeding.
Right.
But I think it could be conflated with its original underlying. claim.
Yeah, so let's go back, because, you know, so somebody, a petition for summary determination has been allowed.
Or you
And
could say,
now-
the court allows a PF.
Yes, that's what I'm saying. If the court has allowed a claim of a creditor under section,
Yeah.
under the, then, but that doesn't go under 4A, because,
Have to be,
Allowed or not allowed.
Right.
My
some
point is
claims
this-
are automatically allowed just by time.
oh,
Yeah, they haven't been disputed, so they're allowed.
They
It's just
weren't
we haven't been
disputed,
paid.
but it's allowed.
So
So
I
just
think
say
what
it's
this
an
is
allowed
saying
claim.
That in this particular
I-
petition for summary review proceeding, if the court rules in favor of the creditor, then the court shall order the affiant. So I think that's what we're trying to say here, is that when, in the PSR, if they allow the creditor's petition as opposed to claim.
So
What do we
trying to
get out of
connect
B that
this-
we don't already get out of A?
Yeah.
oh,
Yeah, good question.
I think B, we, actually took from the end of the summary determination.
yes, that's right.
And put in here because there was concern about the fact that in summary determination, current law requires the court to order
Right.
payment of the claim.
And we're saying we want that to happen
John
in,
didn't want that to trump the other priorities.
right,
Right, and I think we fixed that with the reference to the extent of,
yeah,
palatable.
right. But we've also, we have created a little it's just a little, a flow problem there.
But I agree with Chris's question, is what are we getting from B that isn't already in A?
to the extent of the property of the estate.
So I feel like we were trying to connect this to when you get your claim allowed under 12, and then
Right.
it says there, you enforce it.
Yes.
Or, am I repeating what everybody understands?
No, go ahead, yes, but sometimes repetition is a good thing. It's a feature.
So, I think we were trying to connect those dots, that, okay, you've gotten your claim allowed, under summary determination, tells you to go enforce it under summary review. If the court enforces your claim that was previously allowed, then the court's gonna enter this order.
So we could cover the extent language in 4A. We could say on the third line, to pay creditors of the estate to the extent of property of the estate allocable for payment of the claim pursuant to.
Well, that then breaks what we're intending to do with A, because A is talking about allowing us to pay out of the estate.
Or, that's
Yeah.
true, yeah, that's true.
Well, and we want to be consistent with our terms, because we do define in, claiming successor includes any creditor of the estate entitled.
Yes,
I'm not sure that B is necessary, even for the reason that Marissa was pointing out. If summary determination already says you enforce it through summary review.
Yeah.
yeah,
Then you just file summary review. It's clear that you have that mechanism. I mean, obviously, as long as you're filing within the time period.
right.
and summary
Maybe that's
review.
it, yeah.
Okay, do you want me to put in something about the, to the extent of the?
Well, it's already in there
Oh,
a
it's
little
in there.
bit, because it says to pay creditors of the estate from property of the estate. That's in.
Or of the affiant.
Or of the affiant.
Okay.
So maybe we just don't need B at all.
Okay.
Yeah.
By B.
Okay, in the interest of time, B's out. Summary determination. C, the court may remove the affiant if the affiant failed to comply with, those are the claim statutes, and, 560,
That's-
what's
no,
560?
That's
Yeah.
the whole small estate.
Oh, yes, sorry. That's 5, sorry. Surcharge the affiant for any loss caused. Well, there we are, there's your, there's the liability,
Yeah, it's just lost there.
okay? Bingo, let's go on to, section 19. This is the distribution. If a petition to appoint a PR is not filed within 4 months after filing a small estate, after the completion of the 4-month period, after all unsecured creditors of the estate have been paid to the extent of property of the estate, and before completion of the 2-year period, the affiant shall transfer the interest of the decedent in remaining property or proceeds of property described in the affidavit to the persons entitled.
Oh my God.
That is a lot.
But I understand what it is. It's gotta be, it's after 4 months, after you've paid the claims, and before 2 years.
Well, somebody's gonna have to make a diagram of that one.
Well, I mean, if we, we're struggling to understand this.
What's that? Oh, okay.
Would it be something that would make more sense if we separated the paragraph into
Well, I mean, I tried that, but see how
A,
there's,
B, C?
I know, but see how we've got this except at the end, it makes it very hard to do it. But
Oh.
I can try to do it, but we've got a lot of things we wanna tabulate in this thought, which makes it difficult.
Okay, let's try it again.
Would it work to put the excepts in front?
Or you could say, except it's provided in section such and such.
Right, right. And then make all the exceptions a sub 2.
Yeah, that could work. Okay, I can work on that. I will mess around with this. How about that?
Okay, but we're okay with the mechanics of this anyway. It's after 4 months, after all the unsecured creditors have been paid to the extent of property.
What about taxes?
That's a creditor.
Yeah.
After 4 months.
And we don't want to say after taxes have been paid, because that creates the problem.
Right, but unpaid, yeah, that's true.
Yeah.
Yeah.
And before completion of the 2-year period established in 114.550. Before completion. Okay, so you've got after 4, there's the window to distribute. After 4 months and before 2 years. And if you haven't done it within 2 years, then a claiming successor can file a petition for summary review within 60 days and force you to distribute. Okay, here are the exceptions. Here are the exceptions. Except as otherwise provided in 540, 545 and 550 and section 12. Okay, whatever those are. For the purpose of a surviving spouse's, well, I guess bottom line is if none of those statutes actually bar anything, well, it's ineffective language anyway. B, for the purposes of a surviving spouse's claim, okay, that's current law. Notwithstanding, so this is an exception to the exception. Notwithstanding paragraph A, if petition for summary review has been filed, the affidavit may not transfer the interest in the property described in the affidavit until all claims allowed in summary review proceeding. Okay.
Ooh,
What?
so now we have that same language, all claims allowed in the summary
Yeah.
review. Claims are not gonna be allowed.
Right.
In summary review.
Determined?
Enforce?
Well, no, because the court doesn't enforce it, the court just orders all claims.
Presented?
No, not presented.
Petition?
It's not about the claims at all, it's about whatever the court ordered on summary review.
Until
Compliance with?
compliance with the orders of the court and the summary review.
Let's see. Notwithstanding, if a petition for summary review has been filed, the affiant may not transfer the interest of the decedent in the property described in the affidavit until
Complying with the judge's order?
Until the affiant has complied with any order of the court entered in the summary review proceeding. Okay? Because it may be to pay, it may be to deliver, it may be to do something else. So, may not transfer until the affiant has complied with any order entered in the summary review proceeding. Okay?
To the extent of the property of the estate? Or is that?
No, that's
part of
built
the-
into summary review.
Okay. Okay.
Probably not an issue, but
Good, then don't raise it.
we're saying, can't transfer property of the decedent until order has been complied with, but there's a strong probability order is going to require transfer of property. And if we can't transfer property until we comply with the order, we have to transfer property to comply with the order.
It's a circular.
I think.
Well, wait a second though, but what we're talking about here is basically the ultimate transfer. This is all about the ultimate transfer to the person's, entitled. I mean, that's what this is all about. This is an exception to 1A. So that's a specific transfer. Well, but they may be saying we're entitled to the transfer of the property.
Right,
Yeah.
right. Well, maybe
We've created
what
a
we
catch-22.
say, any portion of the order, except for the final transfer or something.
Oh, my gosh.
I know, it's, this whole section is a nightmare of readability.
Summary review.
Like the rest of the chapter.
Oh, no, this is worse.
We lawyers can't
Yeah.
figure it out.
But then, that's weird. I think that's weird property, and you really, you know, it has nothing to do with it,
Get rid of this thing.
property.
Well, so maybe we make this a condition to the distribution. The following things have to happen before distribution, you know, this, and then compliance with any provisions of the order from, on summary review, except for distribution. Help with your.
Sure, yeah, go
Yeah.
for it, I always like when you help.
Well, yeah, except after the first of the year.
Okay, so let's go to 3, because Marissa will work on, we understand, we all agree on the mechanics of what we're talking about, right? It's just a question of
The wording.
stating it in a way that can be understood.
Yeah.
And that expresses the mechanics. Okay, so I mean, that's good. We're down to just little details here. Sub 3, when the affiant transfers interest in real property, the
I
affiant
don't
shall,
think we did 2,
well,
we don't care about 2.
oh, I'm sorry. Property conveyed by an affiant under this section is subject to liens and encumbrances against the decedent or the estate of the decedent. Property conveyed by an affiant under this section is subject to the rights of creditors of the decedent or the estate until the expiration of the 2-year period.
Hasn't it already passed by definition?
No, because this is talking about doing it after 4 months or before 2 years, yeah.
Where are you?
Sub 2. Second sentence, property conveyed by an affiant under this section, maybe we should say before the expiration of the 2-year period.
Well, that's a section.
I suppose so, that's, okay, yeah, okay. Property conveyed by an affiant under this section, you're right, is subject to the rights of creditors of the decedent or the estate of the decedent until the expiration of the 2-year period established in 114.550. That's fine. 3, when an affiant transfers interest in real property, the affiant shall cause to be recorded in the deed records a bargain and sale deed conveying the property to the person entitled.
Records of the county in the, that doesn't.
Huh?
I think the typo.
Yeah, it's the, deed records of the county in the real property.
Oh,
In which,
in which? Conveying the property,
You're lucky you got us to watch it back.
yeah, to the person, do we need to say person or persons?
No.
No, okay, because singular includes the plural? Okay.
I mean, if you think it's important, I could put it over.
I'd like it. We've chopped off a few words elsewhere, we can add a couple here. Executed in the manner required by chapter 93, when the affiant transfers an interest in a manufactured, oh, yeah. Oh, have we already, no, that's, do we need to include the same language for motor vehicle then too? Because this, we did motor vehicle and manufactured home when we're transferring to third parties.
Yeah.
We should probably add the same language for motor vehicles here.
I wonder if there's a reason why we decided we can.
I don't think so. Okay? Except for conforming amendments, that takes us to the end of 88. So let's buzz to 2957. I think this is just about done.
So what about the statutory form of the small state affidavit?
We're gonna get to that.
Oh,
Well, do we wanna do that while we still have this?
No, I wanna get, these are just about ready to go. Let's get these off the table.
So which one is
2957,
29.
dated December 14th.
Okay.
We'll come back to the form and the proposed changes that relate to the form. Marissa is finding it, so she can tell us what's new.
These ones, I sent an email on the 14th, if you're looking at it.
Okay.
Are you finding us?
Yeah.
Okay.
Yeah, takes me a minute.
Yeah, that's all right.
Okay,
Till 14,
yeah.
Okay,
I'm
so what's
trying to
new?
look at our changes.
because there was very little that we did to this one.
Oh.
Yeah,
I'm having trouble finding any changes in here. Okay, so, I took out financial accounts, now we just have a copy of the most
Right.
recent statement.
Wait,
That
section, what
in
section is that? That's,
Section 10 on page 9.
wow, no changes before then.
Oh, on page 8, I guess I took it, we had a rule of the court that I took
Yeah,
out.
okay,
Then,
Okay, we got that out.
yep,
in that same section, if you go kind of on the same page, paragraph C.
wait, are we on 10? Are we on 10?
yeah, 10.
Page 10?
Page 9.
Page 9,
Page 9,
okay. Oh, okay, all right.
So, instead of saying that the creditor can object to the statement, we have a creditor entitled to notice under this paragraph made by written notice to the personal representative, require the
Right.
personal representative. I feel like there's a comma missing somewhere in there, but anyway, yes, so we, instead of just the object, we changed it to by written notice.
Should that be by written objection to the personal representative or by written notice to the personal representative?
So we're on page 9?
Yes.
And
Sub C,
Sub
C, big, little c.
Little c.
Upon filing a
Okay,
statement, the
okay.
personal representative shall mail a copy of the statement to each creditor whose claim has not been paid or allowed, disputed, within 30 days after the date of the notice. A creditor entitled to notice of this paragraph may by written.
Oh, I'm sorry, I did change that, I'm looking at my changes. I changed that because there were so many notices in here, I put in objection. So, if you don't like that, we can do something else, but it felt like there was the notice, and then the creditor was gonna give notice, so who knows what notice we were talking about anymore, so I changed that to objection.
Go back to page 8.
Okay,
So we took out the rule,
yes,
but, so.
where are you? What section? 3A, right,
Unless otherwise provided by order. of
right,
the court.
yeah.
So, I mean, what are the standards for that?
A judge wanting to make an order?
Yeah,
Yeah.
Full discretion.
So, just on its own volition, the court orders, you can't do this, and obviate the statute.
That's a concern to me.
Yeah.
You know, the presiding judge could make an order.
Yeah.
Well, you know,
Why not just take that out altogether?
Right.
Well,
no, that was part of the balance, and this is Jeff's comment. I mean, we don't even know if Jeff's comment.
Yeah,
Jeff
yeah.
Messenger, Judge Tennyson is not in favor of this, and we wanted to give some option for the court to.
but I agree, we don't want to have a blanket order, because that
Yeah,
just,
good cause shown or something, you know, if this, something has to go wrong, you know, somebody has to be found undeserving of this procedure.
Yeah.
Or order.
On a case-by-case basis.
yeah,
Well, we have that up above under 1A unless the court orders otherwise.
So does she want the ability to make it a blanket order? No, we're not gonna do that.
I don't think so.
Oh,
Doesn't,
I don't
And
think
we have it
any
in
judge-
sub 2, little d, unless otherwise provided by order or rule of the court.
where's the,
so there could be cases where they're just, it's too messy. We don't wanna have that.
there's another.
There's lots of
mention.
opportunities for the court to order.
right. But,
At the beginning,
Mhm.
so this is all about this statement in lieu.
of the annual account,
Yeah, and it seems to me that say you're at the first, annual accounting, court has pretty limited information at that point about whether anything's going wrong.
Correct.
It seems largely that the court was just
Yeah,
going to be
that one you can't waive. Right.
kind of acting on a hunch that something about this filing makes me want further information.
But I can,
Filing meaning like stuff that's in.
right, but I can see a judge somewhere in the state just having an order that they enter in every case.
That may be.
But
Yeah.
wouldn't that, this is Rita, wouldn't that be abuse of discretion?
Lawyers would
Wouldn't
think
you
so.
have to have- I could see that at the front end, the heirs are, I don't know, all convicted felons or something.
Right, right,
I'm
right.
really concerned about this, and, you know, I'm gonna want this information because I've got two devisees that are minor children. And so I say, you know, you're gonna have to file this all the way through because of X, Y, and Z. Just a
And that-
blanket order?
No, I think that is an appropriate situation for an order. How do we allow that but not allow just the standing order that gets entered in every case without any kind of review or consideration that just says you can't file a statement in lieu? Do we say for good cause?
Do we say that for a judge, or that the judge has to have good cause?
Well, for good cause shown requires a hearing.
Yeah.
Yeah, but that's the petitioner showing good cause, not the judge.
Yeah. Well, somebody's got to bring it, somebody's got to make an objection or something, but it's
Well,
so. it's-
no, Rita's saying the judge could do it.
Any beneficiary can revoke their waiver, the beneficiaries don't have to waive this. And if you got minor children, how are you gonna get that waived anyhow?
You probably shouldn't.
Well, maybe what we say is upon motion of any party or the court's own motion.
It's like sua sponte, isn't that what that, you know, the court doing it on their own in this case? But we don't.
Yeah, do we want,
I don't think we need the parties, because it
Yeah.
can't happen unless the parties consent to it.
Oh, that's
We
true.
already
That's true,
addressed-
that's true.
We addressed the creditors by giving them the objection option. So this really was just if the court
Okay,
has concern.
if the court is going to do that, do we want to give the PR an opportunity for a hearing? Before they're disallowed this? I mean, that would avoid the blanket.
Like, do we really want to add
That's a
to the probate process a hearing
No.
on whether this is?
Yeah, that's
complex
true,
enough
that's
to
true.
require something?
Basically, every county but Multnomah, you'll be waiting 6 weeks for a hearing.
Yeah, right, no, that's a bad idea. I withdraw the motion.
I mean,
Maybe we just have to live with this and see how it works.
if it's any consolation, you see verified statements get filed, and you don't see judges going, no, I want you to go do a final accounting. There are a few cases like that where there are indications that there needs to be an accounting, but that's not like a blanket thing
All
that
right.
judges are doing.
So let's do this, again, interest of time. Let's leave the language as it is, add a robust comment that says it is not the intent that this order be a blanket order or an order entered in every case, but be based on some circumstances known to the court that justifies the requirement. And so if you get one of these things, a judge is entering every case, you've got that comment that you can go to them and say, that you're not doing it right. Legislative history,
That's good.
yeah.
The other thing is, if a judge gets one that smells funny, they still. have
That's
the power to
absolutely
say,
right,
"No."
just, okay, yeah, I'm just talking about, I think what we want to avoid, what I want to avoid is the case where you've got just a county that decides we're gonna enter an order in every case, no matter what, it's a standard order, it's not a standing order, but it's in each case, and I just think we ought to have a comment that says the intent of this is that it be based on some circumstances that, inform the judge that a limitation on this right, opportunity should be imposed. Okay?
And that order, if it comes early, it doesn't take effect until the.
Yeah, until the end, that's right, so you got time to argue about it.
Plenty of time for
Yep,
Ryan Davis.
that's right, Ryan Davis. Okay, where else, we were somewhere else, C, on page 9.
Little C.
Little
Oh,
c,
yeah, yeah.
upon filing a statement, the personal representative mail a copy to each creditor within 30 days after they have notice. The
But is it a notice or?
No, yeah.
So I made an objection, like I said, because.
Wait, no.
Oh,
Within 30 days after how about after the date of of a date of mailing of the statement? Because we're not saying notice in the first sentence.
oh, okay.
Then that might open,
Yeah,
then that might allow the creditor to file a notice. Within 30 days after the date of mailing of the statement, a creditor may file written notice, made by written notice to the PR required. Yeah, that notice works.
A creditor,
So then it's a creditor entitled to a copy of the statement?
Yes,
Receive the statement.
right.
Okay, made by written notice, requires a response.
Made by written notice to the PR, require the PR to make and file an account.
Within 30 days of the date of, see, this is where that's the notice again. Okay.
Yeah, of the creditor's notice or something
Yeah,
like that, if
yeah,
we need to
yeah.
clarify that. Okay.
Proposal for shortening,
but wait,
Please.
Wait, Matt,
within 30 days after the date of mailing, I don't care if you want of the notice, or of the statement or whatever, such creditor, because we've just identified the creditors whose claim has not been paid and allowed or disputed.
We really don't do such.
yeah.
I feel like we've been pulling such out in a bunch of other places.
said.
But we do say a creditor entitled to notice under this paragraph.
Yeah, that was the phrase I was thinking we could shorten, but if we don't do such as then.
Yeah, we don't do such as.
Well, but the other thing that bothers me is that we start that very long sentence with within 30 days of the date of the mailing, and then we end it with within 30 days of the date of the mailing. And-
Well, that's what I said, of the creditor's
Of
notice.
the creditor's notice, I think makes sense.
Yeah,
Oh, okay, of the
Yeah.
creditor's notice.
right.
Okay.
I think we need that there.
Yeah,
Okay, I'm gonna declare this one done.
that was the end of it.
Yep. Let's go on to, quickly, on to 889. And I think the only thing we have there really to talk about, let me make sure. But I will say, I think we're going to pull notice to, where were we, in section, was it section?
Oh, because of the objection.
Yes. We've got a battle looming over, section 3, sub 3. I think we just pull it.
Did everyone see the notice sent about that?
Yeah, you said that.
Yeah, we did hear back from a couple folks from OTLA.
And they basically said, we're going to war over this.
Over our collective dead bodies.
It's a pretty clear term.
Shannon, would you agree with that?
It was pretty overwhelming. I would agree with that, yeah.
Well, here's what bothers me then, is some counties do it this way, and then others don't. And it doesn't really seem, it bothers me when we have these inconsistent policies in the state.
So what Brooks told me,
What?
is that it has nothing to do with fairness or right,
Right,
it's just a political decision.
that's right. Yep.
It's easier.
And the plaintiffs' lawyers have a lot of political.
Oh, they do.
And they're gonna make a big deal out of
Yep.
it, so.
Yep. We live with it.
Then we just take it out.
We live with it. Yep.
Okay.
What else did we change in this one? Any of you, if anybody wants to individually go to your legislator, you've got the language here to bring forward as an amendment to the bill. I'll bring popcorn for the hearing.
On page 2, H, right at the top, we added in your,
Oh, yeah.
in your petition to approve your
Yes.
settlement, you need to say that
The
amount
PR
of
fee.
fee attributable to a wrongful death claim. Do you like that language?
Is it
Oh,
paid or to be paid?
Which one?
Oh, yeah, to be paid. Uh-huh.
Because it wouldn't be paid.
Right, yeah, good point.
On page 2, right at the top. Then, looks like,
Or you could just say the amount of any personal representative fee.
Attributable. Yeah.
Yeah, that'd be it, 'cause that parallels attorney fee and things like
Yeah.
that. The amount of any
Amount of
personal
any-
representative fee attributable to the wrongful death claim.
Any personal representative.
So we have, new development to me.
What? New to John.
So we're so clear here that, the court has to approve a wrongful death settlement, but not a PI settlement. But Multnomah County,
No, this is PI and wrongful death.
you have to, is this a PI? You have to get court approval of a PI settlement?
If the
Yes.
person's dead.
Okay.
Okay,
So
so
we're good, okay,
Yeah,
that's fine.
okay,
in 4, I just, because we didn't have annual status, it says the court shall defer the bond requirements
Yes.
instead of May, and
Yes.
then an annual report on the status of the claim instead of the annual status report, because we didn't have that.
right.
It looks like I fixed some kind of reference. I'm missing it. Oh, no. It's this. Section 7. Which starts in the.
Middle of,
Yeah.
yeah.
I have to
We're saving paper.
convert all these
We're saving
things
paper.
from that, or my crazy program, sometimes things get screwed up.
Yeah, we got it.
Apparently I was supposed to delete other there and I didn't, so.
What?
At the very beginning.
Oh, and no
it said
assets, yes, right,
assets.
yes, that's right.
In B, it did say the court may accept annual status reports, and now it says the personal representative may file the annual
Okay.
status report.
Mhm.
And then, we changed in C, in lieu of filing a final account,
Right.
the personal representative may do the motion to.
Right, good.
Oh, I did delete other in section 8. I added something about receipts, in the top of page.
Yeah, top of
4 or
page 5. The motion must be accompanied by receipts or other evidence satisfactory to the court showing the damages accepted or recovered have been distributed. Okay?
We happy with that? No.
What?
Oh, that's a good point.
What's that?
Is it damages or proceeds?
Yeah, that's the proceeds.
I'll search for that.
Yeah, I think it is proceeds.
I think that might come from 30.
Do
but
you?
I'll look.
That's the B on section 10?
Wait, no, we're not in section 10 yet.
No, there's a change.
Oh, I got lost, I thought that's where you were going.
No,
In 9, okay, so here we have it again, when proceeds for wrongful death are accepted or recovered.
30 does talk about damages
Yeah,
throughout.
I thought so.
oh, okay, well, do we want to use damages then?
Proceeds actually only appears once in the whole section. I just did a search on that, section 3.
All right, let's use damages. It ties in with 30. It's not gonna confuse anybody. Except for Jeff.
He says with confidence.
Now we have, I added in section 9, an attorney, a lawyer trust account for an attorney representing the plaintiff in the wrongful death.
Or upon order of the court.
Why did I take out decedent here?
Yeah, should be
Attorney
both.
doesn't represent the decedent.
Yeah, personal representative of the, personal representative
Of the estate.
Representative of the estate.
Yeah.
So how will that read ultimately?
It'll say the damages must be placed in the lawyer trust account for an attorney representing the personal representative or of the estate or the plaintiff in the wrongful death claim.
Great, or should
Or
we use
upon order.
plaintiff or the personal representative in the wrongful death claim? I think it would both be the personal representative, right?
We
No.
changed it back from that this last time, because it used to just say the personal representative. And people wanted an attorney for the,
Yeah, because you've got two lawyers, probably, one for the estate and one for the wrongful death. You're right, Shannon, they're both the same client.
Right.
So do we say representing the estate?
Yeah, maybe the attorney representing the personal representative for the probate or the wrongful death claim, something along those lines.
Oh, that's the thought, yeah. The trust account for an attorney representing the personal representative of the estate in the wrongful death claim or the estate?
know that you need that.
I think I've got it here.
What do you have?
I
I
have,
think it was added to try and make clear that it could be either.
Yeah,
yeah,
Last time it just read an attorney for the personal representative of the.
oh, you're right. So, no, that's right, for representing the plaintiff, that's two proceedings, because it is the same client. It's the estate or the PI lawyer. Okay,
So I
Shan,
would read that as excluding the probate lawyer.
you read that as
I
excluding?
read that representing the plaintiff, meaning it
yeah,
has
it's
to
wrong,
go.
I did.
What have
We
you
need to
got?
add in
What have you
the-
got?
The attorney representing the personal representative of the estate or an attorney for the plaintiff in the wrongful death claim.
Except, that's the same person.
Right.
Well, to say any attorney representing the PR.
Because we don't want the PR
That's what it
contract
says for.
attorney.
Right, that's right, yeah.
Right,
Yeah.
that's right.
What difference does it make?
Well, it's gotta have a lawyer that's got a relationship with the claim.
Well, first of all, it's not gonna happen, because the PI lawyer's not gonna let it happen.
Yeah, right.
What difference would it make? It's still protected in a client trust account.
Well, I think I had phrased that you don't, if there could be an ancillary estate in some other state, you
Yeah.
don't want it, you don't want someone.
So what did we say, placed in the lawyer trust account for an attorney representing the personal representative in the estate or the wrongful death claim?
It should be an out-of-state attorney.
Wayne, this is Shannon.
What about
Is
in
it-
Oregon?
Oh, sorry.
Yeah, go ahead, Shannon.
Oh, it's a different subject, so if someone has something to say on this, I'll.
Okay, I think we're there.
Well, do you need to say, lawyer trust account for an Oregon attorney representing the PR in the estate or the wrongful death?
No.
I mean, is that a concern?
For an attorney in Oregon?
Well, if you got, if the claim is.
Yeah, 'cause it
filed
could
by
be-
an attorney,
Be in Washington.
then you're saying it's gotta go to the PRs.
Yeah.
Yeah, those claims are all over.
Yeah, let's just leave it.
Okay, are you ready?
Yeah.
Okay, so 116,173, that's new. That's what we added.
Yeah, this is what John wanted to talk about.
Team, where's?
John,
where's-
Yeah, yeah.
this is section 10.
Oh, okay.
Yeah, indeed.
In E?
B.
B. What? Income received?
B, yeah, B, 2B.
Oh, 2B?
2B.
Oh, PR fee, okay.
Oh, this is the other fix. This is
the Steve Heinrich.
that's right.
Yeah, that's the fix behind your complaint thing. So I'm a little concerned about in the fourth line, as reported in the inventory, every place else. And I'm wondering, do you really report a value if and I think what Steve's complaint was that the property was reported on the inventory at an artificially high value.
Right.
And then it was sold for something considerably less.
Right.
And then you get to the final account reports the assets on hand at the end. So do we really have a reported value in any of the pleadings?
Well, at some point, if you found out that you seriously screwed up the value when you did it in the inventory, aren't you required to file a supplemental inventory noting that screw up?
You can do it in the accounting, can't
No.
you?
But your accounting would then,
Reflect
You do a
that.
verified statement.
Right. So this picks up all of those.
But still, when you do the final account, you just list the assets that are on hand at the end.
Right.
And Blackacre was sold for half of its inventory value. So I'm kind of wondering if this reported in the inventory matters of inventory or final account.
Do you have a better verb?
Well,
Stated?
Shown?
back up, isn't the B is, starts with if the highest value in any of these previously filed documents was materially misstated. I think we added that
Yeah.
to try and capture this sort of thing where
Yeah.
you
Yeah, you're good there.
estimated
Yes.
some major
Right.
claim or asset, and it turned out it was.
Yeah, we're good there. We're in the ballpark. If you got a material misstatement.
The reported thing is in 2A, well, what is now 2A.
Oh, you're right. Reporting inventory is the same language. Yeah. Okay. You okay with it then?
Then it follows with the value that is the highest correctly stated value.
Right.
Of the asset as reported in these pleadings, but I don't know that you're reporting a value in the pleadings when you sell the asset in the meantime.
I think reported is kind of a generic term.
Well, that's what I'm questioning.
Yeah.
So are you thinking, I'm not getting your point, John. You mean like
Well,
as
you file
stated?
inventory, you list back here,
Right,
you sell it for $500,000,
right.
and you file an accounting that says, you know, I got these assets now that do not include back here because it got sold.
Right, but you've listed the sale in your disposition of assets.
Yeah.
Well, yeah, because in your accounting, in your
Right.
narrative statement, you'd have to say
Right.
that. In an accounting, you would.
You sold it for $500,000.
Right.
I think that's a report.
We can clean that up in the commentary.
Okay,
I'm gonna say that because of the.
however it is shown.
Yeah, as shown or
Yeah.
reflected in the.
But I see Marissa has used reported because it's in A, in the current
That doesn't
language.
mean we can't change it, nowhere else, so.
Do we like shown better? Would we change shown?
Or stated?
Should we value it at its?
Yeah, I think it needs a little wordsmithing there to make it.
Well,
clear.
okay, what's a better word than reported then? Is it shown? Is it stated?
Well, it could be reported, as reported or shown. Or something, or reflected.
All right, time's up.
Commentary, but I think that
Okay.
Steve's gonna bitch about this.
You think so?
Yeah, I think he's gonna say, well, if you never report it, then you still get the higher fee, so.
Heinrich.
But I don't know what.
Maybe official.
Oh.
Well, we still haven't discussed that thing.
I don't have the
Huh?
statute,
That
but
This is his issue.
don't you have
We didn't,
the obligation to, well, look, maybe we should just look and see whatever's
This
in
is the
the
fix.
inventory statute and whatever's in the accounting statute, see what verb it uses to describe how you identify the asset.
I thought I said that we didn't.
Yeah, I think it's either amended or fixed in the final account. So you don't necessarily have to.
113, 165 is about the inventory, although I hate using this book because I think we changed it, but.
Each asset shall be valued at.
Yeah, but this is our response to that.
Okay, all right.
Yeah,
okay.
right. Yeah, it's our response to his
It says
issue.
the inventory shall
Yeah, this
show.
language is the thing,
Yeah.
and it said, and then it said I would rather it say something else, so I don't
Yeah.
know, but anyway, here we are.
Okay, so Jennifer just looked up, the inventory language says it shall show.
The estimates of by the personal representative of the fair market.
Shown,
Shown, as
There we
shown
are.
in the inventory.
shown.
Yeah, I like that.
There we are, shown instead of reported, including in A.
So that's in 3 places, in A and twice in B.
Yep,
Yes,
shown, perfect. So the outlier was reported in 1A to begin with. I mean, reported was the
Yeah.
outlier.
yeah.
Okay, all right, we are done. Congratulations.
Just 1 second, Lane, sorry, there was one issue that we didn't finish talking about last meeting, if memory serves, and it's, section 8, sub 4. The fact that we're giving notice of the final accounting to all the heirs under 116.093, but that's the only time they're getting any notice of the wrongful death proceeding.
Oh, yeah.
So what section?
Oh, page
this is-
5.
Yes, section 8, sub 4.
4, okay.
I think that an easy fix right now, if we're tight on time, would just to be that the, notice would go out to the beneficiaries, but consistent with the rest of this section, or we should change the whole section to distribute to heirs, devotees, and beneficiaries throughout the wrongful death probate.
Huh?
So here we're sending notice to everyone under 116.093, but for the rest of this section, we're just sending notice to beneficiaries, as defined under ORS 30. So we should probably, excuse me, sorry, my watch is talking at me. So I was saying that an easy fix to this sub 4 would either be to just have the, mail a copy of the motion to all beneficiaries, or mail a copy of the motion to everyone under 116.093, but then we should also change the notice requirements and throughout the wrongful death probate section. So they
Well,
aren't just getting a copy of the motion, and that's the only thing they receive from this.
And that's a good point, and I guess why would we include anybody but the beneficiaries in this case? Because this is a wrongful death only.
Yeah.
Beneficiaries,
There are creditors of the deceased, of the estate.
but they're not entitled, they're entitled under chapter 30, they're not entitled to, on a motion to close.
I agree with you, Lane, to just have it to the beneficiaries.
So just goes to the beneficiaries as well.
No sense giving a notice if somebody doesn't have a right to object.
Right.
Well, and also you might miss out on some of the beneficiaries because you have stepchildren in the wrongful death statute and not under 116 or
Right.
103.
True.
Yeah, good
So
point.
let's say beneficiaries.
Elaine, this is Cleve. One housekeeping matter, should there be sections that identify when these changes take effect?
Yes.
Oh, thank you.
I mean, I'll do that. I usually do that at the very end, so that I don't have to renumber everything.
Okay, oh, yeah, right.
Yeah.
So just generally, will this apply to decedents who die after the effective date and, well, yeah. You wouldn't want to make this applicable to proceedings pending or estates pending.
So, yeah, that's a good clean.
Yeah, I think it's probably, it has to be decedents who die after the effective date. On all of these. I think.
Well, what
Yeah.
about, but not include people that died before, but whose small estates are
Oh.
started after?
Oh, that's a good thought.
Yeah.
Yeah,
You can
well,
do
that's
it
right.
For the filing ones, you can do it to,
Yep.
petitions filed or whatever.
There we go,
affidavits
decedents
filed,
who die, or maybe we just say petitions filed after.
affidavits filed,
Yeah.
So, I mean, I'll just do my stuff.
Yeah, I think the point is we don't want any of this to apply to pending proceedings as of the effective date.
No.
In any of these, bills. Okay. All right, then I have to leave because I've got a meeting back in Dallas and I was not able to reschedule. But carry on with the, discussion of the form. And let's take a look at the instructions, and then Sandy, let's get a meeting in January.
Either first or second week?
Yep.
Okay, I'll put that schedule in.
Yep.
Probably tomorrow.
I leave for Norway on the 9th, so let's leave before the 9th.
It'll probably be the first week in January then. I'll put out scheduling, today.
Okay, good. Well, and the only thing I'll say before I go too is that then we will need to keep track of both of these bills, and remember, we're gonna talk about, conforming amendments or conflict amendments, so that we clean these up. Okay. All right, carry on, everybody?
And we're separate in this room.
Okay.
I'm sending up the notice.
Excellent, okay. Thanks, everybody. Merry Christmas, Happy Holidays, Happy New Year. All right, Jennifer, do you want to take on the lead in your conversation?
Sure. So this very lengthy statutory form and instruction, that the kind of the genesis of this was there were some forms available for some of the counties, and I think mainly I used Multnomah County, but I looked at the other, Clackamas and Marion and Lynn and different counties. And then I superimposed the new changes in the law that we've made. And then I also add, and kind of in some of this, I was discussing with Judge Kopp what she thought we ought to have, and so I did add in there the affiant duty part, where they are acknowledging what their duties are under the statute. And some of this will have changed just based on what we did today, you know. And so then I took this long draft, and Judge Cobb and I went over it for a couple hours and made some more kind of final tweakings. And one of the things that we decided was this is a way to hold the affiant accountable, and by having them initial these blanks. Because what they can say is, you know, well, gosh, Your Honor, I'm sorry, I didn't know I had to do that. Well, now they're initialing it, it's in the form, they are responsible. And so it will make it clear for the court and for anyone else to say, well, wait a second, you signed here. So that's part of it. Now, the other thing, Judge Cobb, are you still on the phone?
I'm still here.
All right, would
Yeah.
you tell about the review that you had done by the Washington County probate staff?
So one of the things Jennifer and I were talking about was, since this is like 12 pages, are the clerks going to have cardiac arrest when they get these things? So we were talking about how to make it easier for the court staff when they're getting something like this to see that the initials, that's why all the initials are kind of out here to the side so they can kind of go through it. So after we had that discussion, I took this back to the clerks in Washington County and said, you know, when you look at this, could you tell me what you think? And they actually, first of all, they said it'd take some getting used to, and it's like, well, yeah, it's going to for everybody. But they timed themselves, and it only took them like 8 minutes to go all the way through it to check what they're supposed to check, and they thought it looked good.
Oh, wow. So that's kind of how we got to this point. And the other thing is that is different from some of the forms that the counties had was they had more of the instructions in the form, like about specific wordings and things. And so Judge Cobb and I thought, okay, let's make it part of this form that they have to read these very specific instructions, and then just include that information in the instructions. And from what Rita said is, you know, the court staff likes that idea of being able to say, well, read the instructions, or, well, you haven't initialed here or filled in none or whatever, read the instructions. And then that kind of puts the burden on this person who is accepting this responsibility of filing that affidavit. So that's kind of the, you know, the background behind this. A couple of changes. One of the things that needs to happen is however we adopt this, it needs to not be these exact words. It needs to be something that is substantially similar, because, for example, the DHS people need the ability for their lawyers to justify their ability to file this under the law that allows that. It may be that in a custom form, I did a custom form recently where my client was the sole heir and there were no creditors, and so obviously we're not going to send any notices in that situation when there's nobody who has to be noticed. But it should be substantially similar so that the court staff is kind of looking at the same thing all the time. They're not having to see things that are completely reinvented. So that's part of however this would be adopted. I did add in here, I think that there wasn't a reference to a sheet in the forms that the courts were using, that obviously that should be in there, because you can't just ignore some long lost relative. You know, it may be that share has to go to the Department of State Lands or whatever. So I did add that. Now on the original will part, I think I tried to make this as clear as possible. You know, make it clear it has to be an original will, not a copy, and it has to have this affidavit to support the authenticity of it, and that's kind of diverted off to the instructions.
Jennifer,
Mm-hmm.
I had a couple of comments. One is on the instructions. I think it would be a lot more intuitive for somebody reading the instructions if it did like the IRS does on theirs. So it says, for number one, this is how you fill it out. Number two, so forth.
Right, but some of these, like the affiant is not disqualified. You must be able to initial all of the blanks. And so, I mean, some of them are self-explanatory.
I agree.
Okay.
Even if that's so, just something in the instructions that says section, whatever that is, C form.
Okay.
There is that, I think, too. It says, like, you can file C part blank of the form, so it just has to be.
So are you saying have a portion that says go kind of number by number, and so let's say they don't, you know, it's all self-explanatory until the safe deposit box, and then you say question 12, and these are in the instructions. Is that what you meant, or?
I just, when I was looking at the form and then I found I wanted to go back to the instruction, I had to find in the instructions the part that I was looking for.
So maybe a section of the general instructions, because there are like definitions and things that
Right.
don't refer to a specific section,
Right.
and then some kind of division to the instructions that say, and then 4 questions, whatever, and then rather than having, you know, continuing the numbering off the side, it says question 1, self-explanatory C form, question 2, self-explanatory C form, or, you know, questions 1 through whatever, if there's a clump, and then question 7.
So at
something
some
you
place
actually
go
need to fill
number
out.
by number based on what's in the form.
And rather than having it numbered based on, you know, what section of the instructions this is, have the numbering reference back to the question. So if I'm looking at question 12,
Yeah, that relates.
I can look in the instructions and it's just something with a nice bold heading off to the side that says question 12.
If you look at any of the instructions that IRS publishes, they do the same thing. So you can easily go to the instructions and find the specific instruction. The other thing I had was on page 10.
Is this on the
Of which?
instructions?
No, not of the form. Paragraph M, it says, I must file any required tax returns and pay from the estate property any taxes owed. This includes the decedent's final income tax returns. It could also require fiduciary income tax returns. My question is whether or not the IRS will issue a TIN to an appliance.
I think they do now. I think that, because I've done it before, when you have to have a bank account, and the instructions are kind of generic enough, it's kind of like the responsible person or something. But yeah, you can, because you have to do that to have a bank account. You know, the banks have the authority to open a bank account for a small estate.
Not using it.
Right, but they have to have a tax ID number.
No, don't do this, because the affiant is an executive.
Right.
Federal tax law.
Right, yeah, so, well, and I guess one concern, since you raised that point about the filing the tax returns, you know, some of the things that are in this form are not in the statute. And so, but this is, to me, a really important part of administering an estate, that some person coming in off the street just thinks, oh, well, here, I get to take this money. Oh, yeah, there's some creditors. Okay. And, you know, they're not tracking on the whole tax part of it. And so I don't know what the thoughts are about including some of these things that aren't referenced in the statute.
Can we include?
Right.
So Jennifer, I got some concerns, some negative thoughts about this.
Sure, I hear you.
I think it's wonderful to have a form, a standard form that people can use. I think that's wonderful. I don't think it should be in the statute, and I don't think it should be a mandatory form. It should be an optional form. And I look at this, and when you go through this, I can today draft a legally sufficient and correct small estate affidavit in less time than it would take me to go through this form with a client. So if I think the pendulum's kind of gone too far in the pro se direction. I mean, it's wonderful to give all this stuff to the pro se people, but for a lawyer to go through this form and have people initialing things and in dealing with everything, you're gonna double the legal fee associated with a small estate affidavit.
Well, so I think the first question is, do we want a statutory form? And the reality is that we have a form that is being used in a number of different counties, and they're inconsistent. And the other reality is that these pro se people now have this fiduciary responsibility that we've given them under statute. They're ignorant about what their responsibilities are.
I
And
don't even know what fiduciary is.
right,
Can we say that the court must accept this form, but in any other form that addresses the content requirements is
Well, and so that, you know, the
or how
switch,
far apart is substantially the same, yeah.
and the challenge of that, Judge Cobb, why don't you respond to that?
I didn't hear all of the question, but substantially similar, that's the language, Jennifer, you and I were talking about to allow for like John's concerns, right?
Right, and John, the way I would see.
My form would not be substantially similar to this, it's what I use today.
Well, see, my form would be this form, and then I would plug in my form fill-in things so that that things would fill in, and then I would just sit down with my client and they'd have to go through this.
And then substantially similar is determined by a probate clerk, and there's no consistency to what substantially similar would mean. And different people would have different opinions about what substantial and similar means. So, plus I also think that the odds are overwhelming that if you actually, every one of us, after we've done 2 or 3 of these with clients, we're gonna find something we wish was different. So every time, we're gonna be going back to the statute all the time, trying to change it to correct typographical errors and stuff, you know. So I think I'd favor having some sort of enabling legislation to allow the courts to adopt a standard form that would be accepted in all counties, but not make it mandatory.
I mean, that's the UTCR. There are a bunch of UTCR forms.
Well, there's.
And I agree, that's just Clackamas.
I didn't hear what she said.
She said she agrees with Clackamas.
Yeah, but aren't the garnishment forms in the statute? Yeah.
Yeah.
And a lot of real estate
Guardianship
forms.
notices or statutory forms.
I mean, if this is something that we really want to have, then I don't see a problem with it being in the statute. As long as you have that substantially similar language, will also be accepted. This is gonna be the go-to, I mean, this is something for hand people, newer lawyers can grab it, as they become more experienced dealing with it, they can adjust their own forms, DHS can change things if they need to, but, I mean, again, I think the idea here was not just, do we wanna make it, you know, I'm not trying to bend too far over on the side of the pro se person, but on the other hand, we want consistency among all of the courts. I thought that was part of the proof. And if you put it in a UTCR, then each county may have their own little change, and not that that's not okay, but this way you've got this is the standard, and then from there, you know, you give the authority to make something, as long as it's substantially the same, court will accept it. But then you don't
But
get
it won't be
36,
substantially the same.
what?
It won't be substantially the same. It'll be completely different.
Then you can't have it if it's completely different. You have to follow this protocol.
Well, that's the objection I've got. 'Cause
I
it's
understand,
doubling-
but that's the
it's-
same
it's
objection
doubling
people had
the
about
legal
garnishment forms and conservatorships and everything else, and those are in statute. So, and, you know, I think that if this is the goal, then I think that this is where it belongs.
I don't think it's the right goal. That's my point. I don't think there should be a statutory form designed to protect pro se people from screwing up their job, that lawyers have to follow. I mean, I can do a small estate affidavit in very little time, because I know what information is relevant. I don't have to go through this rigmarole about having people initial everything and not to explain everything that they're gonna initial. This is worse than the advance directive. And everybody's scared to death about making any changes to the advance directive, because it's gotta be substantially in that form.
No, it has to be in exactly that form. That's what it says in that advanced directive form, is it basically, the only way to deviate is to write into the blank.
And that's what we did with we created a task force that would, with the advanced directive, we created a task force that would promulgate, do advanced directives once. So it doesn't have to go back to the legislature every time for the direction, every time for the application.
Yeah, it does.
And that's my problem with this, because this substantially similar stuff is not a lot of wiggle room. And it's gotta look pretty much like the same thing, and you could change a line here or a word there maybe, but it's gotta look kind of like that. And I'm gonna do an affidavit that is exactly in compliance with the statute, and it's gonna get bounced because the clerk's gonna say, well, it's not substantially similar to this.
So Brian, what percentage of,
I'm not Brian.
I'm sorry. Yeah. What percentage of the small state affidavits you receive are prepared by lawyers?
10%?
How much?
Less, 10% or less. And no offense, John, but I'm not sure we're bouncing it for not being substantially similar to what we're expecting. When we look at like notices to protected persons for their objections and things like that, pretty much every lawyer has their own form. We're not bouncing it for like the typeset or the format. We're looking to see whether it contains the information that the statute is directing to have. And if someone's homemade small estate is going to have less than what we're expecting to see, that would be a reason to bounce it, but not if it's shuffled around in different orders or it's still covering all of those things.
You don't have to say the form is substantially the same, but the content is substantially the same. Maybe that, you know,
Well,
but
The biggest question I would have,
The stuff, any of this stuff.
90% of these are not lawyers doing it though.
Yeah, but
90%.
well, why would you wanna make that 98%? Would you
It's
rather make
also
it
not
20
our
or
job
50?
to create more work for lawyers. I mean, that's not what.
Yeah, it is,
Oh my God.
cause it's how you get better.
So you get more money is what that.
I
No.
mean, honestly,
This is creating more work for lawyers, cause we're gonna have to charge people more.
it took 8 minutes for people to fill this out. 8 minutes.
And I don't see having to charge.
We have it set up in our system.
Right,
As a form.
right,
Then we're only filling in the blanks. It's
Right.
not that difficult.
so the question I would have is, would an attorney-assisted version require the same initialing?
yes. I think that's important because
I mean,
Not disagree, just clarify.
right.
in my opinion, the initialing on a pro se form is an acknowledgement that they are checking all of the things that they're required to do. If they have counsel and we're trusting that their counsel is doing it, I don't care about the initials necessarily.
Well, I suppose that would be a compromise.
I was thinking that would be the first substantially similar change I would make is change paragraph 1 to read, instead of my initials, my signature,
At the end of
and
the
remove
document.
all of the initial lines.
Yeah.
And
For lawyers.
Or do a separate oath of office.
This is Clackamas. I can tell you, people are going to put their initials on it and not do what it says.
But
Yeah.
this is Judge Cobb, but the point is, when they have in fact initialed it, if you didn't read it and I'm looking at this and you violated whatever it is on this form, I get to say, but Mr. Jones, you've initialed right here and you're stuck. It's an evidentiary issue, I think. And Mr. Jones, if you're just willy-nilly putting your initials, you're doing it at your own risk.
But don't we have that same thing when they sign under the declaration? I mean,
No, not a form of this length and filling in all of these allegations. You're alleging different things in this and saying, yes, I've done this, or yes, I will do this.
Well, I mean, if that is the biggest stumbling block to an attorney prepared form is the initialing, then we can make that exception in the statute. That, a form prepared by an attorney's office does not require the initial.
It's noon and I have to go.
Oh,
It is, time check, it is noon. Sorry, I mean, I can stay for a while if anyone likes.
no, I gotta go.
So I will send out a schedule request for the first week of January, and hopefully we can get something scheduled soon. Thank you, everyone. Thank you, everyone on the phone.
And then did we address?
No.
Okay.
You.